On April 13, 2026, Uganda's High Court Criminal Division implemented a mobile court model for the first time less than 2 months after its official rollout. The initiative follows a legal notice number 1 of 2026 issued on 24 February 2026 by Chief Justice Flavian Zeija, aimed at guiding both magistrates and High Court judges in conducting mobile court sessions. Under this framework, judicial officers are permitted to convene court proceedings in locations they consider appropriate. The goal is to improve access to justice, provide easy access to justice to refugee camps, host communities, enable operation of mobile courts, strengthen existing processes to facilitate speedy delivery of justice in both civil and criminal matters, particularly in communities directly affected by crime. While the concept may appear new to many, similar approaches have long been used by the Uganda People's Defense Force through its General Court Martial. A notable example dates back to March 21, 2002, when an Irish Catholic priest, Declan O'Toole, and 2 others were ambushed and killed along the Moroto-Kotido Road. 2 soldiers, Corporal James Omedio and Private Abdallah Muhammad, were arrested 4 days later. A field court-martial was convened in Kotido, where the trial, conviction, and sentencing were completed in less than 10 hours. The 2 were sentenced to death and executed shortly after in a process witnessed by over 1,000 people. The incident drew widespread criticism, with concerns raised about violations of the right to a fair hearing and appeal. The Uganda Law Society later challenged the precedent, and the Constitutional Court ruled that Articles 28 and 128 of the Constitution that guarantees fair trial and judicial independence had been violated. Although the UPDF has not carried out execution since that ruling, it has continued to use mobile court-martial sessions in various cases. In 2013, a UPDF soldier, Private Occult Patrick Odoch, was tried in a field court-martial in Bombo after killing 10 people in a bar. These included civilians and fellow soldiers. Despite prosecution requests for a death penalty, he was sentenced to 90 years in prison on multiple charges, including murder, attempted murder, and robbery. The trial lasted approximately 6 weeks. More recently, in 2024, the UPDF extended this model beyond Uganda's borders, conducting court-martial sessions in Somalia to try its officers. The approach has also been applied in areas such as Agago, where crimes committed by soldiers within communities are handled through localized court sessions. The mobile court model has now entered civilian judicial processes following a directive by President Yoweri Museveni. This came after the tragic killing of 4 children at a daycare center in Gaba. The president ordered the suspect, Christopher Okello Onyum, be tried before the community where the crime occurred. Okello pleaded not guilty, leaving the burden on the prosecution to prove its case beyond reasonable doubt. Prosecution has, however, presented 18 witnesses, including daycare staff, parents, police forensic experts, and medical professionals. The presiding judge, Alice Komhanj Kauka, has ruled that, based on the evidence brought before court, Okello has a case to answer. Although this is a case of immense public interest, the Uganda Law Society has warned that the speed of proceedings in Okello's case could undermine constitutional guarantees of a fair trial and contradicts earlier Constitutional Court rulings on Articles 28 and 128 of the Constitution. Legal minds have argued that while timely justice is essential, excessively expedited trials risk compromising due process. The debate raises critical question: if justice delayed is justice denied, can accelerated trials still ensure fairness and equity? As proceedings continue, the outcome of this case may set a significant precedent for the future of mobile courts in Uganda's civilian justice system.